Thanks again for staying with us on your ultimate news and current affairs program on television, TMI Thursday. Okay, in the build-up to the 2023 election, particularly as it relates to the Electoral Act as amended, there seems to be a huge controversy there. You recall that last year, the Electoral Act was a major talking point, and that's because of the clause that was included or inserted by the National Assembly as part of efforts to rework the electoral amendment to make it more in tune and in tandem with the tenets of democracy. It was the mode of primaries that was the subject of controversy at the time, where the NAS members felt it wise to say that the only mode of primary will be direct. And then reaction and counter-reactions trailed that until Mr. President asked them to delete that section from the Electoral Act. Well, eventually, after much pressure, they bowed and did delete that clause or that section from the Electoral Act. Mr. President went ahead to sign it. And after signing it, all of a sudden they realized that there was even a more controversial section of the Constitution, of the Electoral Act, that was left unattended to. Perhaps they would have included it as part of the demands for the assent to the Electoral Act. We're talking about Section 84, subsection 12, which talks about the fact that any appointee cannot be part of the voting process and can be voted for in the primaries of a political party, except such an appointee has resigned his appointment. But that is not the end of the story, because as we know today, a federal high court has already quashed that by asking that the section should be deleted. And the Attorney General and Minister of Justice, Malami SAN, has gone ahead to do that. And that seems to be the basis of the conversation that we're having this morning. Let me thank very especially Idris Zakari, is a political analyst. Idris, thanks for coming.
Thank you so much for having me. It's always a pleasure to be here.
We also have Barrister St. Michael Agwalgie, who is a civil society human rights lawyer. Thank you for joining us.
Thank you so much. It's a pleasure to be back here again.
Barrister Emmanuel Obakbolo is a constitutional lawyer. Barrister Emmanuel, thank you for coming on the program.
Good morning, Nigerians. Good morning, Sunday.
Let me start with the lawyers to set the tone for this conversation. What is it about Section 84? As a matter of fact, because that seems to be where all the problems have been coming from, yes, as it relates to the electoral. What is it about it really that has brought us to where we are with all the issues that are going back and forth? Barrister Emmanuel, let me start with you.
You know, the political dispensation we find ourselves just now is one that spells out more particularly the interests of the executive.
Okay.
I want to start by laying this foundation. Looking at the Nigerian Constitution itself, the Nigerian Constitution has 67 powers. 67. Out of that 67 powers, 64, powers is given to the executive, particularly the president.
Okay.
One to the legislature, another one to the judiciary. Then the remainder one is now shared between the executive and the legislature. That is to say, out of 67 powers, the executive has 65.
So you just have only two left.
Yeah.
Shared between the legislature and the judiciary.
And because of that vested strength encapsulated or encapsulates by the Constitution, which now vests powers on the executive in this dispensation now think it can turn woman to man, man to woman at will. And that is why you see anything that is perceived in the laws to have reduced the powers of the executive is frowned out. And that's why today, you see, they never saw the provisions of Section 84:12 until more recent, when they now say, this may not favor some persons within the kitchen cabinet of the president. Now, to my mind, Section 84, I think, is one of the sections of the Constitution that checkmates the powers, the delegated powers of the executive. Now, if we go back to the same Constitution, Section 5 of the Constitution vested power on the legislature to make laws, while Section 6 is for the judiciary to interpret the laws. By so doing, the judiciary at times, in decided cases, also make laws, just as the one that is causing controversy just now. But my worry is that Section 84:12 should stand, but the executive just now is not interested in it, because some persons within the presidency and within the kitchen cabinet of the president want to grab power. Thereby, there is this opportunity or privilege for them to use the instrumentality of government to so grab that power. So the legislature in their wisdom saw this coming, and I said, look, you cannot take part on conventions or primary elections within the internal affairs of the political parties.
Okay.
Because since 1999 till now, we have seen that some of these persons who are so endued with this legislative, executive delegation on them, have used the instrumentality of government to gain more strength. So the legislation has said, no, we cannot checkmate these men. So it's those persons who are now shouting out. You can see how the Attorney General of the Federation is quick to say, I want to implement. Is it within his powers to so do?
Okay,
the answer is a capital no.
Okay, we'll look at that. Let's get your foundation on this conversation, Vice President Michael Agwagi.
In this argument, at the very just now, I'm neither here nor there.
A lady to the left, a lady to the right. Okay.
Let me start, perhaps, by complimenting the position of my learned friend here. It is true that the Attorney General does not have the powers that he has been clouted with by the court judgment or court order, so to speak. However, when we look at the issues on the table, we'll discover that Section 84, sub 12, only seek to exclude political appointees from participating either in primaries or in convention. And strictly speaking, when you look at those provisions and you read them, you read that provisions in line with certain other provisions of the Constitution, like Section 66, Section 105, Section 107, and Section 182 of the 1999 Constitution as amended, you will discover that the said provision is constitutionally offensive. The Constitution of the Federal Republic of Nigeria, empowers, permits a citizen, any citizen, that is not suffering from any legal disability whatsoever, from participating in any election in Nigeria, whether primary, whether convention, or the general election.
Okay.
So to that extent, any act that seek, to divest any citizen that does not suffer any legal disability, as stated in the Constitution, will be struck down by the court.
Okay.
For being inconsistent with the relevant provisions of the Constitution. And Section 1, Sub 1 of the 1999 Constitution provides very expressly and clearly that if there's any law for the time being enforced in Nigeria that is inconsistent with the provision of this constitution, that provision, that law, shall be declared null and void. Why? Because the Constitution of the Federal Republic of Nigeria is not just the ground norm, it is the faucet origo of the land. It is the supreme law. However, I like to posit very clearly that in striking down that provision that seeks to divest certain individual of certain rights guaranteed under the Constitution,
Political rights.
the judiciary has done the right thing by way of performing their constitutional function, which has to do with law interpretation. However, I only frown at the aspect of the judgments which seek to transfer, to confer, to clothe a certain individual with certain power that he does not enjoy, constitutionally speaking.
That's the Attorney General of the Federation.
Exactly.
Okay.
Because in interpreting the law, the judge would have ended. But the judge went too far when he empowered a personnel, an aide of the presidency, somebody from the executive arm. You not confer him with the power, to delete such provision from a law that was rightly and legally legislated upon by an arm of government. That runs against the spirit of separation of power. And in my mind, it amounts to judicial rascality.
Okay. Thank you very much, Barrister St. Michael Ogwalge. Zakaria, you've been listening to them quietly, and I'm sure you also made up your mind on some of the perspectives that you have on this issue. Would you say this was a deliberate effort by the National Assembly to undermine the executive, whether at the presidential level or the national level, state level, or even at the local government level, as the case may be?
Well, when you have to speak after two very enlightened lawyers have spoken, you know the kind of position I'm sitting in right now. However, I will not go into the sections and the subsections, the laws and the bylaws, the separation and the unseparation of powers. I will still talk of the political consequences of some of the actions we are seeing now. We have a system where everybody is working and behaving in such a way that they want to preserve themselves, politically speaking. And whereas this power of preservation and determination has remained with the governors and the president hitherto, the legislators are now trying to divest some of those powers so that they will have a say and a stake in whatever happens in the political process. How so? I give you an example. Let's bring it home to Edo State, for example. We all know that the governor of Edo State today is not on the same page with his political party, the PDP. In 2023, we are going to have primaries. And automatically, once you are in a position, according to the law of the land as of today, drawing strength from the judgment of the High Court, that political appointees now can participate in the electoral process, the primaries, for example. Any appointee of the governor, he becomes an automatic delegate in his political party. It then means, since the governor does not enjoy majority, instead of exploring political options to solve this problem, reaching out to the political party, making peace with his party, he can simply decide to appoint 1,000 SSEs, take them to the convention, and any candidate the governor picks becomes the candidate automatically. It is the same with the president, but most of these abuses we have known majorly from the governor. That is why, Mr. Sonny Duke, few months to election, like we had in the last Edo State election, governors will appoint thousands of senior special assistants, some senior special assistants that sit under the mango tree in government house, numerous of them, take them to the convention, get what they want, and immediately after election, disband them till the next 3 months to election. These are some of the political consequences. But let's look at the legislative side. These guys in the legislature have realized, the honorables, let me be more respectful, the distinguished senators and the honorable members, even when they behave dishonorable most times, have realized that if we continue to operate this system, we will live under the whims and caprices of our various state governors and political leaders in our states. So decided to divest power. Now, if you remove all the aides of the president and all the aides of the governors from the primary process, it then means it's going to be one man, one vote. You have to work now because, you know, the legislators are closer to the people. They are from constituencies. They interact directly with their constituents. They have more stake at home than the governor is sitting in Benin. For example, my 8th Federal Constituency House of Rep member is closer to me than the governor who is sitting in Benin. It's natural. That's the way it is. They now know that they will be able to argue out their case, fight out their case in their various domains without the undue influence. Look, the governors are so powerful that if they want to, for example, let me pick again, I like making it practical. If they want to, if the governor now wants to take over his constituency and put his candidate there, all he needs to do is to appoint 1,000 aides from his constituency. When they go to primaries, the governor has won. Look, we are looking at Buhari and his ministers. We are not looking at the consequences down below. And that is where the secret is, the governors and their people. But let's even talk about Abuja. By this law, if not, save for this court judgment now, the likes of Rotimi Amechi are technically out of the presidential race. How so? Malami himself, the Malami now, the implementing officer. So you see the wisdom.
Is it not providing a level playing field for everybody? Because you said this law would have provided a one-man, one-vote system.
Yes, it would have.
Yes.
On the face of it. But on the politics of it, you are already alienating individuals. That means that I am more qualified to be president than you. But the spirit of the Constitution says that we are all equal in aspiring for office. So Malemi is out, and Ngege is out, and Amechi is out, and it's double jeopardy. If you now decide to resign from your office and go and run for president, you have lost the influence of your office. It then means you have become a normal citizen like the rest of us. No more police escort, no more paraphernalia of office, then we slug it out on the street.
But that gives you advantage and is a disadvantage to such people who do not have the opportunity to be in such positions.
Mr. Sonny Duke, politics operates on the principles of a seesaw. If it favors me, it will not favor you. If it favors you, it will not favor me, politically speaking. The legislators have done their calculations. And you know why? I, for example, I would have supported this law on the strength that someone like my governor Godwin Obaseki, has to be tamed so that he does not oppress his party. I would have supported this law. But today, it has favored me because I don't like Godwin Obaseki. Tomorrow, I may have a governor that I don't say you don't like.
Just giving an okay. No, go ahead.
Yes, it may favor me because I don't like the man.
But let's try and stay on course. You know,
tomorrow
we're not talking about those. Let's try and stay on course. Zekiri, stay on course.
This is an Edo State station.
Idris, stay on course.
No, this is an Edo State station, and we are speaking to Edo audience, and
we are speaking to the world. Edo State is part of the world.
You see this law we are talking about? I am talking about the way it affects me in Edo State. I am not in Abuja. I don't know Malami. What's my concern with him? So we are talking in Edo State. I would have said yes, let this law stay so that the governor's people will lose in the next primaries in his political party, the PDP. However, why I am not why I am not completely in favor of it is that today he favor me. Tomorrow, when it's now against me, I will no longer have the voice to cry. So it's important that the Constitution that has said all citizens, according to let me borrow a leaf from my lawyer friend, all citizens who do not have legislative, what do you call it again? Legislative disability.
Yes,
legal disability are qualified to run for office. We should stay with it because it is more all-encompassing, it is more far-reaching, it has better coverage for the citizens. But politically speaking, this law even favors me. The governors need to whittle down some of their powers. The powers are too much. The governors especially. The governors.
Is the same relates to the president's
yes, but
the president power
the
is
president
also,
has enormous powers.
Yes, just like the governors.
By virtue of his office and by the moral burden that office carries, the president can do but little with his powers.
How?
When I say little, in terms of politics now, the president cannot come now and go and start picking legislators in the various federal constituencies. It's not easy.
He can do it by proxy.
He can do it by proxy, but it's not so easy.
We have seen president before who picked governors.
Sonny Duke, let me give you an example.
Yes.
Let's say, for example, the president has interest in who becomes federal legislator representing 8 federal constituency where I come from. You don't expect the president now to not go and pick 1,000 SSCs from 8 West. He will now have to consider the principle of federal character. But you see, these are our governors, especially the ones we have around here. let me not say more than that.
All right, thank you. Because you know, definitely I would have put a stop to it. Anyway, let me come to Barrister Emmanuel. You concluded by saying that the AGF, who has been saddled with the onerous task of enforcing this law or implementing the law as it were, or the judgment as it were, does not have the powers. I didn't quite get that.
Yes, by virtue of the, I started by helping us and Nigerians to know that the Constitution itself makes provision for who is vested with the power to make laws. And I did quote Section 5 of the extant Constitution and also Section 6 of the extant Constitution, wherein I said that Section 5 gives powers to the legislature to make laws and also vests power on the judiciary to interpret the law. And when the judiciary interprets law, by so doing at times, the judiciary also make laws. I started that. A 300 level law student knows that. So now looking at it from that angle, I also said that the Constitution of Nigeria provided 67 powers. And out of the 65 to the executive. And the powers so vested in the executive, the president and the various governors, they also have the legal right to delegate some of these powers. And those they delegate these powers to, they use it as if they are the owners of the powers. We've seen that, particularly in this administration, particularly in this dispensation. We've seen that the AGF has been caught in so many web of confusion and controversies as it stands today. So it is sad that he is still deepening himself into that. He does not have that power. He is an appointee, a mere appointee, and he stands so. He does not. The legislature has the power to make laws. That power cannot be delegated to him. It cannot. In the spirit and letters of the Constitution, he does not have that legal right or constitutional right.
So was the court right in adjudicating on this matter to the point of asking that this section of the Constitution should be deleted?
Deleted, expunged, removed, whatever. The court was not right. Very wrong. To my mind, the National Assembly was not made a party.
What's the implication of that?
Good. You cannot, a man that has committed or a man that has done wrong, now you want to take the man to court and you choose to take the man's cousin to court instead of the man. How are you going to interpret that? What adjective would you use to qualify that act? So, to my mind, the court, I don't know, I see it as a legal abracadabra. I don't know how the court arrived at its judgment. I do not know. But also, the court should have asked, one, the principle of local standard. Who has the right to sue? And who should be sued in this matter? I think the court should have asked that. Therein, the court would have known that maybe there was some arrangement by a group of persons who want to ridicule the court. This manner of judicial rascality, to my mind, should not be embraced. The Constitution itself is the ground norm. The Constitution has provided for how things should be done.
Okay.
So for a court to now sit and determine a matter where the main party, as we call it, the proper party who ought to be in court was not in court, and you are determining that matter on who and to who.
So what is now the ground of plans to appeal the judgment on the part of the National Assembly?
Yes, I think as at yesterday, they did say they want to go to court.
Yes.
Yes.
Good chambers.
Yes, and by virtue of section 228 of the Constitution, I think they have the right to appeal that matter.
Yes.
And I want to assure you, if the judiciary does not want to mess up itself, that judgment should be set aside.
Let me get your views on this. Yeah.
Just to...
Yeah, the fact that this matter was taken to court and they got a judgment, I should be deleted, which has already been implemented. Yeah.
You see, let me, move back here, like the Benis will say. Let me bring a searchlight very clearly on the matter. In my introductory remark, I said that the court was right in striking down these provisions.
Yes.
On the ground that the provisions are constitutionally offensive. Then I also said that it was wrong for the court to take a step further, because the court would have ended there. Those who feel aggrieved cannot seek redress at the apex court.
Okay.
But because there is, a pecuniary interest that is, controlling, the issues from behind, the court did not end there. The court went further to empower the same Malami who has a vested interest in this whole matter to be the one to now delete this provision from an act that has been legislated upon and assented to by the president. Because if you look at the relevant provision of the Constitution, it is the person who have the power to make laws that also have the power to either delete or amend. So what the court ought to have done was to, mandate the House to amend that section or leave it at that. Because whatever is struck down by the court is not implementable unless it has been appealed on the ground of ubi jus, ibi remedial. Where there is a right, there is always a remedy. Mr. Soliduke, but the court did not do that because everything that transpired had political connotation. The judgment itself was made to appease and accentuate a political arithmetic. And that political arithmetic, has not gone further to undermine the spirit of separation of power and democracy itself. And that is why I said that the action of the judge, so to speak, amounts to judicial rascality. And the apex court does not address this. We have...
Okay. So Zachary, is this a political judgment?
Well, to the extent that Attorney General Malemi was asked to delete that clause from the provision, from the Electoral Act, it makes it a political judgment, in my view.
Okay.
But the judgment, the lead up to it, is not so political, because it's easy to see. In fact, the entire, that clause as a whole is enmeshed in politics. It starts and ends with politics. It is a battle for influence between the executive and the legislators. It is a battle to exclude some potential presidential candidates, governorship candidates from the 2023 elections. It means if I am a commissioner under a state governor, I cannot contest to be governor in an election. Otherwise, I should. But let's even go back a little bit. In the constitution, the lawyers are here to correct me if I am wrong. There is a provision that if you are a public servant, 30 days before an election, you must resign your office. What is so interesting in it again now, that these people have now further stretched it that if you are a public servant, political appointee, adding political appointee now, you will not even participate in the electoral process by way of primaries. Are you now in and conventions? Are you now indirectly saying that political appointees do not have political opinion? And again, the constitution made it clear that you have the right to hold an opinion. So when you remove that right, it then means you are already trying to oppress some people in favor of others. Everything starts and ends with politics, Mr. Sonny Duke. And until we separate politics from governance, we will not make the kind of progress we are looking to make. I told you earlier that this one favors me today. Tomorrow, if it does not favor me, I come here to cry, then I'll be speaking from both sides of my mouth. Yeah. It's better we let it be the way it is. Yes, whoever will win today will win. But at the end of the day, democracy will be the ultimate beneficiary. That's the way I see it.
All right, if you just join us, it's still TMI Thursday. We are extraying the provisions of the Electoral Act section 84, subsection 12, that is bringing forth a lot of controversy between the executive and the legislature. As at the last count, a court ruled that it should be deleted from the Electoral Act, with the Attorney General, Minister of Justice empowered to do that. And then we hear that the National Assembly are also spoiling for a showdown by approaching the court to appeal the judgment. We're looking forward to how all of this will pan out. But ultimately, this has been viewed as an attempt to whittle down the powers of the executive. And from all indications, it doesn't look like it's going in the favor of the legislature. Is this a concern to you, Barrister Manuel?
It is. It is a concern to every Nigerian. Because over the time, we've seen that democracy that Nigeria just now is practicing has not favored Nigerians, but rather it has favored a selected personalities, so to speak. Now, if you look at the controversy, like in our local parlance, we say where two elephants fight, it is the grass that we suffer. Nigerians are the ones to bear the brunt, as it stands just now. So there is a power tussle between the executive and the legislature, as it stands just now. And looking at the powers, the Constitution vests on the executive. The legislature is just realizing just now that, look, this man has so much powers, and it's like we have more or less none given to us. Okay. So if out of 67, they have 65, and we have just one, then we should not struggle to have more to ourselves. And that is the battle. So now they are fighting, they are struggling for strength, they are struggling for power. Nigerians, we are watching at them. But be that as it may, we cannot just sit down and watch at them and say, let us see where they will land. Okay. Because wherever they land, we affect us.
Absolutely.
We impact us. So for that reason, that is why this morning we are here, to ensure that we enlighten Nigerians on the power tussle going on between the executive and the legislature. And that is an utmost concern to me as a Nigerian. Okay. Because if this power tussle is not resolved, because I say the only way this power tussle can be resolved is still politically. The courts cannot be used to resolve it. Because already we see that the court somehow, somewhere, has been misled. And now, what the court needs to do to preserve its purity is to ensure that there is a political solution to this tussle going on. So that at the end of the day, we will not begin to use different adjectives to qualify the judiciary. because whatsoever adjective we use to qualify an unbiased umpire that it ought to be, we go a long way to affect the whole system.
Okay.
So we advise that both the legislature and the executive, just like they sat together to resolve on how to
mode of primaries.
Mode of
primaries.
Yes.
Wherein they now say, oh, we don't want a Portuguese kind of assembly. We now remove the people from the deciding who becomes a political leader in a particular party. I think they should stow the same line so that the matter can be resolved politically.
All right, thank you very much. Let me get Barrister Gwage to look at this. There are sections of the Constitution that already make such a provision as to how someone who is holding a public office is supposed to participate in government. Section 182, Section 318, section of the 1990 Constitution has already stipulated this. So what then is the relevance, if I may ask, of this section of the Electoral Act, as it were, if it were to stand?
The section on that discourse is a political missile.
Shot by who? Shot by who? Certainly not any one of us here in the studio. Shot by who?
A supersonic one at that. You know, shot by a Putin who sat with his disciples, coming up with a political arithmetic and permutation to exclude his political foes from the upcoming primaries in the APC. It is the APC that is...
It's Saturday. It's on Saturday here.
It's not even the PDP.
Today is Thursday. Friday, Saturday.
30 persons are the targets. So that was why I said, when the court is interpreting a law, they are allowed to employ certain rules. We have the neutral rule, we have the golden rule, we have the mischief rule. In employing the mischief rule, the court will ask itself, what is the mischief this law is meant to kill? In doing that, the court is permitted to embark on an historical journey, taking an helicopter view of what has transpired, what is, and what will be. In the mind of the court, the mischief has already been adequately taken care of by the provision Barrister Sonny Duke just quoted.
No, Mr. Sonny Duke, please.
It has already been adequately taken care of.
Okay.
So why overstretch it? You know, the Constitution already said that public servants will not be allowed to participate in the process. They must resign
30 days to the time of election.
Why not extend it
to primaries
appointees?
So it was done in bad faith, is that what you're saying?
It was done, you know, in utmost bad faith. In utmost bad faith. And that was why I said it was right for that provision to be struck down. But however, what the court did is tantamount to the three of us here who were invited as panelists to this program. All of a sudden, we not just sit down and do an election. And now elect me to be the one asking questions on this platform.
So did you, because you had...
I'll become a panelist or I'll become an audience.
An audience.
Without no amount to power usurpation, that's exactly what the court has done. The court, you know, in doing the right thing, ended up with a disaster.
Okay.
By way of usurping the powers of the legislature. It is the legislature that have the power to make law. If any law is to be deleted, it is the legislature who make the law in the first place and
That will still remove
that.
it.
Okay, against that background.
Go by way of amendment, because the property to do in this case, because the law has been legislated upon, it has been passed, it has been accepted to. The property to do is to amend it.
Not to delete it.
Empowering
an individual,
an interested party
to delete it.
To delete it. That's
okay.
Are
these political words?
Subterfuge.
Okay. Are these lacunas that can be exploited, and political parties? Is there anything you think they should be wary of? Because now these lacunas, like you guys have exposed, are there. One of the political parties will be having its convention on
Saturday.
On Saturday, but I heard some saying that look, they're probably going to bar, political appointees from participating. Or something. I've not been able to confirm that. But is there something we should be concerned about against the background that the National Assembly is already saying they want to take this case further?
Well, clearly, like he said, there is a missile. And starting Saturday, some shrapnels of it are going to start exploding. I watched an honorable of the House of Rep yesterday in a sister station, and he said, well, those who think the legislators don't know what they are, they should go and contest and wait for judgment of a superior court. It then means that if I'm a political appointee today and I participate in the primaries of Saturday, maybe as a delegate, maybe as a contestant, and I win elections, on the strength of that, chances are that if judgment goes against me tomorrow, it has invalidated what I've done previously. So maybe the lawyers in the House will still let us know, maybe as at the time of that primaries, since there's a standing order striking out that clause, it then means maybe it can stand. That is for the judiciary to interpret. I am not a lawyer. I'm only talking about the implications of the laws they have made. But in the long run, these implications will rub off badly on us. That's what I'm saying today. I say today, it does not favor those state governor. I'm happy because I'm not a fan of his. Tomorrow, there will be a governor. A time will come when there will be a governor where I will be a fan of. And these things will now work against the governor, and I will come out to cry.
What's the quarrel with Edo State governor?
No, it's because I'm in Edo State. This is my primary constituency.
Let's try and stay on course.
Yeah, it's the course that we are saying.
Stay on course. Stay on course.
So, in a nutshell, it's a booby trap, and I think the APC, being the majority party in the country, should be more than this. The president should have a hands-on approach to solving problems. Okay. If he thinks hands-on approach don't work, look at the way he has succeeded in averting the crisis he created by removing an elected leader of his party, tenured leader of his party, the APC, in the presence of Adam Shimola as national chairman, then by fiat, by word of mouth, removed him from office. Somebody who has a tenure like you removed him from office, and now it has created problems for the party that they are just trying to solve just now. How many years down the line? 2 years of crisis. Imagine what you can achieve in 2 years if everything was in place. It is the same thing that we are seeing in Edo State. I always talk of Edo State and people quarrel about it. With the illegal harmonization of the PDP by the governor.
Zachary, I have to stop you there. Let me just take us back to this controversial section of the Electoral Act as amended, section 84:12. Let me read what it says. It says, no political appointee at any level shall be voting delegate or be voted for at the convention or congress of any political party for the purpose of the nomination of candidates for any election. Now you understand why many of the political appointees
are jittery,
are worried, are concerned.
See it as a missile.
I don't know if it's a missile, but I'm just looking at it the way it is. But this is supposed to have far-reaching implications. I've heard people talk about the fact that this will make government appointment unattractive. Do you subscribe to this? Let me begin with you.
Absolutely.
To make it unattractive?
Yes, my learned friend here is against that provision. But I, for one, am not against that provision of the law. owing to the fact that the Constitution itself has created more controversies than we think. And that's why some of us are calling for the total repeal of these documents, the extant Constitution. And in one of the fora, I did ask questions about the confab that former President Jonathan constituted, and how some brilliant, intelligent Nigerians came up with a constitution, with a proposed constitution, so to speak. And that document today is being wrapped with dust somewhere. We don't know whether it has life or not. Now, Solid Duke, sir, if you look at this provision, yes, it appears to be a battle between the legislature and
the executive.
In quote, appointed executive. In quote now, not elected executive. Now, if you look at it, you discover that the elected executive put up more rascality, executive rascality, than the elected ones.
Than the unelected ones? Or,
yes.
Or than the appointed
ones?
The
appointed ones put up more executive rascality than the elected ones. And owing to that fact, the legislature now came up to say, look, we need to checkmate these guys, because these are the guys who do, in quote and unquote, the dirty jobs for the executive. Sorry for mentioning this name, with all due respect to him. Somebody like Amechi, Rotimi Amechi, we saw how he used his executive position to trouble River State, because he couldn't get what he wants.
But he was also being troubled. He
was
troubled.
He was troubled out of office.
So it was a fight for survival, political survival.
He was troubled out of office.
That is applicable to the 36 states of the Federation. That is applicable. So the legislature, in their wisdom now, and I say, look, we need to checkmate these guys. And just like the Constitution of itself also makes provision that, look, if you need to, you can resign so time, so that you can now go into election proper and contest. But be it as it may, the ruling party just now, just like my friend here said, my co-panelist said,
the ruling party that do state of
Nigeria has created more problems for itself than for Nigerians.
Very true.
And that is why you see their convention is 48 hours or so from now. And now, here is the controversy, the legal controversy of the matter. So, the little advice some of us can give to them, if they have sense, if they want to key into reasonability, the would-be convention should be postponed. But also, there is a time frame within which you can conduct your convention before the election. So, I think some of us are not owing them any explanation. Some of us are happier that is happening like this, because what they told us in 2014 is not what they are doing. So let them also be caught in the web of confusion and controversy.
All right, let me get Mr. Gwagas to call it the wrap now. There's a law in existence that regulates civil servants' participation in politics. Excluding them from participating, except
the bracket of public,
except you resign. There's a duration within which you resign, so you don't. I believe part of the reason that law was crafted, so you don't take undue advantage of your office to promote your political career. Yes,
does not extend to political appointments.
Exactly the point I'm making. Exactly the big. Isn't it morally right that you have such a law regulating political appointees, just the same way you have regulating civil servants' participation in politics?
Well,
it's a tough one.
It's a tough one.
It's a tough one.
I just thinking about it.
Mr.
So let's get reactions from you guys. Yeah.
The question you are asking is called the devil's question. You know, but I will wriggle myself out.
I trust you. I trust you can do that.
You see, the reason why that law was made to exclude, public servants is because public servants have, more stake in the political process. Such that if you allow them to participate, they have the capacity and the resources, to alter the process, to their own interests and benefits. That was why that law.
But political appointees, political
public servant who is a political servant.
Okay, let's get your reaction. Let me get your reaction on this. Yes, quickly before we.
The answer should come from the definition of who a public servant is
and who
a public office holder is.
Yes.
Now, if you look at a public servant is the machinery that carries out the day-to-day running of government.
Civil servants,
Then the public servants holders are political appointees who go there to enjoy after the public servants.
Shouldn't there be a law regulating their participation in politics?
There should be law.
In fairness,
I still have the floor.
Yes.
I was the one.
Okay.
I was the one.
Yes. So
addressing the issue.
Go ahead because I have limited time now. Shouldn't there be a law regulating them?
Stepped on my tongue.
Yes. Go ahead.
You see, the political appointees are not public servants.
Absolutely, we know that. They
were neither elected nor employed by the state, to help, carry out.
They were employed, in a sense. They were employed,
appointed.
They were appointed by an elected officer.
Yes.
To help them carry out. To help them carry out their function.
Yes.
To help them do their job.
So for that reason, there shouldn't be a regulation on that.
Whatsoever.
So let me get your concluding statements on that.
Public servants. Let's take for example, because I like bringing my own home. Not Edo State now. I'm sorry, but let's say let's say a major general in the army is a public servant, or a commissioner of police, or the inspector general of police, or an AIG. A major general in the army, maybe who is in charge of Edo State, is that interested in being governor? And he has 10,000 soldiers attached to him. He will ride everybody and come. You know the outcome already. It's a disaster for democracy.
Okay.
When you allow them, that's why the law.
How about his chief of staff, for example?
That
same office.
That's why the law debarred them from participating.
Okay.
But you see, it's trying to separate a political appointee from the appointer. It's like separating the vine from the branch. They are one and the same. Without the tree, there is no vine. All right. So they are appointed on the whims and caprice of the governors and the executive. Okay. And in any case, most governors will say, if you are in my cabinet and you are interested in running for office, resign. So that you don't distract me.
Okay.
So most governors will do that. In Niger State, the governor just said, if you are interested in being running for any office and you are in my cabinet, please resign now.
Resign now.
Speaking to those whose interest he doesn't have.
Now, let's talk about the legislators that are bringing this kind of obnoxious law.
Yes.
Do they have legislative aids? Why did they not debar themselves from participating in the process?
This law would have also affected them.
No, it does
Ultimately, it would have affected them. It would. Look at it critically. It certainly would have affected them. Anyway, gentlemen, my time is up. I want to thank you guys for making it out here today and being part of the discussion, helping to shaping and deepen our conversations on Section 84, subsection 12 of the Electoral Act as amended. I'm sure we'll keep our fingers crossed, really, and wait till how the NAS will take the matter to the appeal court and maybe to the Supreme Court. I don't know.
Before they come back, Commission would have been completed.
So more controversy.
Thank you very much, Vice Emmanuel Obakpolo. Thank you for coming. Vice Gwagi, thank you for coming. Idris, thanks. It's always like having you guys here.
Thank you so much.
We'll take a short break. A whole lot is coming up after this.